Good morning, Your Honors.
morning.
My name is Thomas Hutto. I'm a member of the Murray County Bar. I'm here on behalf of the appellants, the estate of Toni Marie Harris and Sabrina Cox in her role as the personal representative of that estate. And I'd like to reserve 2 minutes for rebuttal.
2 minutes. All right, sir. You may proceed.
Thank you. I know there are a myriad of issues in my brief. I plan to focus today on the abuse of discretion in the trial court's failure to grant the motion for summary judgment for the appellates and the formation of an enforceable contract and whether or not, if there was one or if there wasn't one, whether a breach occurred. And first, though, I'd like to clarify what this case is not about. It's not about a contract, a debt, or an obligation incurred by the decedent, Mrs. Harris, during her lifetime. It is about whether Ms. Cox, as the estate's personal representative, could have performed this contract by July 10th, 2020, after the appellees claimed that under Ms. Harris's will, title vested in the heirs of her stepfather, Philip M. Harris, and not in Ms. Cox. The first issue, though, is that the trial court should have granted the appellant's motion for summary judgment as a matter of law. If we look at the appellant's motion for summary judgment and the statement of undisputed material facts, the appellant submitted 28 undisputed material facts, and the appellees agreed that 17 of those facts were undisputed. There were 11 more facts that the appellees disputed without providing any citation to the record. If we look at what's not in dispute, we've got the closing date was July 10th, 2020. The appellee's final closing disclosure from their lender has a closing date of July 15th, 2020, and that's the first day that funds could have been dispersed from their lender. None of the parties signed an extension of the closing date, and there's not a written agreement to do that. The appellee's title company didn't prepare any closing documents. The appellees did not appear at a closing on July 10th, 2020. They did not provide any funds on the closing date or put them into escrow. No loan funds were received on behalf of the appellees by their title company on or before the closing date. And 15 days before closing, the appellees asserted that Ms. Cox was not vested in title, and this prevented the closing. This fact specifically was not disputed by the appellees. The 11 facts the appellees did dispute are in Volume 4 of the record at pages 516 and 517. You'll see they lack a citation to the record or support by any affidavit or exhibit. Tennessee Rules of Civil Procedure 56.03 and Tennessee case law requires that citation to the record, and it's a mandatory requirement. It is capable of waiver, but as a matter of law, the trial court should have found that no material facts were in dispute due to this failure to follow those rules and case law. And the court, like I said, does have discretion to waive this rule, but waiving this for 11 facts that are both uncited and unresponsive to the appellee's statements is an abuse of discretion. For example, in the appellant's statement of undisputed material facts at paragraph 20, the appellant's fact is that the plaintiffs assert in their sworn discovery responses that they now believe that Toni Harris's husband's heirs are the heirs to the insolvent estate and also the property, and plaintiffs now believe that Toni Harris's husband, Mr. Harris's heirs, are actually the sole heirs of the insolvent estate and also the sole heirs of the property. And this is cited to the record from the discovery responses that were filed in this matter. The appellee's response is disputed. Defendant's counsel sent a notice of insolvency to plaintiff's counsel, which is where the allegation that the estate may be insolvent originated. No citation, and that's not responsive to our statement of fact. These responses, the 17 undisputed facts and the 11 facts were disputed, but not disputed as required by TRCP 5603, established that Sabrina Cox did not have authority to execute this contract, was not vested in title, and that the heirs of Philip M. Harris were not before the court and were not parties to the contract. They also established that due to federal law and the appellee's own closing disclosure, the appellees could not close before July 15th, 2020. These facts and the case law show that there's no enforceable contract, no breach, and that the appellees were not ready, willing, and able to close on July 10th, 2020, and summary judgment should have been granted to the appellants. Because at this point, at the time of summary judgment, the appellee's claim for specific performance as a remedy was still before the court. They did not dismiss that until just before trial. And then moving to trial, the proof there showed that Ms. Cox did not inherit the real property. As the personal representative, she could not execute any of the deeds or the closing documents, and the bequest to Philip M. Harris, her stepfather, lapsed because he passed away before Mrs. Harris, and so her estate would go to Philip M. Harris's heirs. Ms. Cox is the stepdaughter of Philip Harris. He has at least 3 other children that Ms. Cox knows of. She's in contact with one of them. Neither she nor that son knows where the other 2 might be, other than possibly in California. The appellee's title company and their expert witness testified that they would not allow Ms. Cox to sign the closing documents and deeds. The appellant's title company would not allow it either. At the time of the signing of the contract, the personal representative did believe that she had inherited the property and could sell it. And the appellees at least believed the seller on this contract owned the property and can sell it, and the court's order highlights this point explicitly. However, Ms. Cox also couldn't sign the required affidavits of heirship, as she's not a child of Mr. Harris and she's not a disinterested party. And then what the proof didn't show at trial is the appellees showed no proof of damages with regard to rent or moving costs or repairs, although they were alleged in their complaint. They didn't show any proof of the fair market value of the property as the closing date, and there's no proof of the attorney's fees in the record. There's never a hearing on them, there's not a motion, there's not an entrance of an affidavit of attorney's fees at trial or before trial. And so without these numbers being substantiated, the appellees don't have any damages, and the attorney's fee award in the order fails completely in every respect to comply with Rule of Professional Conduct 1.5 and the case law that sets out how trial judges should determine whether attorney's fees are reasonable. Despite these facts, though, the trial court found that Mrs. Cox, the personal representative, was liable for signing a contract to sell real property. The court found she had no authority to sign any closing documents, though, to complete the contract. Found that she did not inherit the property, and her mother's will did not give her the right to sell or manage the real property, and this estate was not insolvent. This inconsistency, that Ms. Cox could sign the contract and not the closing documents, coupled with the court's finding that both parties believed the property was either vested in Ms. Cox or that she had the authority to sell it as the estate's personal representative, shows a mutual mistake of fact. After the appellees alleged the title was not vested in Ms. Cox on June 25th, 2020, though, further performance by Ms. Cox was impossible. And Hunt versus Twisdale holds that one of the things in a contract that can be a mutual mistake or a mistake, it says some examples of material and vital mistakes include mistakes as to the existence of title. This contract also is not one the personal representative was performing pursuant to TCA 66-4101. It's not a sale under the insolvent estate statutes or TCA 30-2-401. And the record shows there's no claims made against the estate, and the appellee's complaint for specific performance is not a claim against the estate itself. A claim for specific performance is properly made against the heirs to the estate, as they are the necessary parties as held in Wright versus Universal Tire. So an enforceable contract, of course, results from the meeting of the minds of the parties to the contract. There was a meeting of the minds initially when this contract was executed. It was based on the mistaken belief that Serena Cox could sign the closing documents and convey the property. Once the appellees alleged that Serena Cox had not inherited the property, there was no longer any meeting of the minds. The heirs of Philip M. Harris, the alleged owners, were not parties of the contract. Real property vests at the death of the...
What's the significance of that you've got theoretically other people who own the real estate that are not parties to this contract?
Well, for a contract to be enforceable, it has to be made with the parties who own the property and have the authority to sell it.
Was this litigation for the purposes of specific performance or damages?
It was initially a complaint for breach of contract, damages, and specific performance.
Okay, and so how did it come out? Was it simply a damage issue then?
3 or 4 weeks before trial, the appellees dismissed their claim for specific performance, and and then at trial or just before trial, they dismissed Ms. Cox individually as a defendant, And so the case went to trial solely on the issue of damages, and I guess breach of contract and the damages.
Damages solely against the estate itself.
Mhm.
Okay.
Or against the personal representative of the estate.
Was there a difference between the estate and the personal representative of the estate?
I believe there's some in that the personal representative is there to administer the estate, to disperse the funds. The estate itself is an entity that has to act through its, I guess, personal representative. So there's not much difference, but I believe there's some.
So your client's defense was this was a mutual mistake of fact.
It is. It's that.
Was that the defense in the trial court?
Yes, that has been our defense, that once they alleged Ms. Cox was not the owner of this property, even though that she had a good faith belief based on her initial probate's legal counsel that she had inherited under the will, that she was mistaken about it. The appellees were in some way mistaken about who had the authority and was vested in title. And so it became impossible for her to sign a deed, sign the closing documents, which is what the appellees proved and what the trial court found, that she couldn't sign the deeds to convey the property. She wasn't an heir that could sign the affidavits of heirship. And in between June 25th and July 10th, it was impossible to find out-of-state heirs that there's no address, phone number, or contact information for, or the disinterested party. And I don't think the trial court delved very far into whether or not the disinterested party could be found.
So why did the trial court not then apply the mutual mistake of fact?
Your Honor, honestly, I don't know why they didn't say there was a mutual mistake, because it found that that belief was there and that it was incorrect on both sides, and that Ms. Cox didn't have authority to sign any documents after that was determined.
Did it specifically, wasn't this a bench trial?
It was.
Did it make a specific ruling about the application of that defense?
No, Your Honor, it provided, the order is 68 unnumbered paragraphs of facts that generally follow the testimony given, and then there's no specific facts set out saying this is what the ruling is based on, and there's no specific conclusions of law either that the trial court sets out separately as required. It just then awards judgment to the plaintiffs.
Okay.
Was that the trial court's order that was entered? Did the trial court prepare that order? Or was that a submission by the party?
It was a submission by the parties. And I believe the trial court asked both parties to submit orders, didn't let us know what its decision was, and then use those two orders to either in full or in part in the order that it
in full or
issued.
in part, which is it?
Well, I don't know. There's I think about 6 sentences that I recognize from the order I submitted, and there's another 60 odd ones in the actual order. So the 11 paragraphs that the trial court decrees after that are not anything I submitted.
Thank you.
Good morning, Your Honors. My name is Kathleen Robson Gordon,
Would
and
you
my
mind pulling that microphone down to you a little bit?
shorter than the other people.
Thank you.
My name is Kathleen Robson Gordon. My co-counsel Huntley and I represent the appellees, Mr. and Mrs. Hoffman. I believe the central question in the appeal is whether Sabrina Cox, acting as the executor of the estate, had the authority to enter into a contract with the Hoffmans for the sale of this property. And the answer is yes. Ms. Cox had the ability to contract. She breached the valid contract, rendering the estate liable for the breach under two different theories. First,
What gave her the authority to contract to
It's-
sell that property?
yes, Your Honor. The face of the will required that the will be administered under California law. Unlike Tennessee, when someone dies in Tennessee, even when someone with a will, the property passes directly to the heirs at death. California, the property passes into the probate estate to be administered by the executor of that estate. Under California law, as the executor of the estate, she had the authority to enter into this contract if entering into this contract was in the best interests of the heirs. We submit she's not an heir based on the face of the will. She was disinherited by her mother. Somehow, she still got appointed executor of the estate. The record shows that she has a stepbrother who we also spoke with, who had no problem selling the property prior to the sale date. The allegations are that he doesn't know who his siblings are or where they are, how many they are. They may be in California. Over the course of the last 4.5 years, while this probate estate's been open, she's done nothing to find these heirs. No motion to serve by publication, nothing. So as to the best interest of the estate, when they filed the probate petition, they listed the real property as being valued at $209,000. The contract with the Hoffmans was for $17,000 more than that. I think it was net $228,000. Okay, so at that time, it was being sold for more than what they thought it was worth. That money could have been put into the estate. Instead, she didn't move forward with the closing. She didn't try to move forward with the closing. Both title
I'm
companies.
still trying to figure out how she could close on that property. You mentioned something about a California statute.
Correct. Under California law,
You don't have choice of law provisions in wills, do you?
the California will says the personal representative will petition the court to allow it to be administered under its California Independent Administrative of Estates Act.
Can you cite me to the language in that
Yes.
California statute that you say gives her authority to do that?
Yes. I'll cite it. It's from the Charles B. Weber Real Estate versus Rickard, California Court of Appeals, November 29, 1971. Our decision is in accord with legislative policy for administration of decedents' estates. When a person dies, title to his real property passes to the person to whom it is devised or bequeathed, or to the persons who succeed to his estate, subject to the possession of the representative and control of the probate court for purposes of administration, which is Probate Code 300. The representative, unless bound by an executory contract for the conveyance of real property, is free to decide whether the property is to be sold or held for distribution to the heirs, depending on the best interests and financial circumstances of the property. So, under...
And that's for a will of a California resident
Correct.
involving property in California.
It's for a will of a California resident, but in this was a very short will. It was a 2-page will. So no real property was, the address specifically delineated. It came under the residuary of the estate. So I think it'd be property she owned anywhere. At the time she executed the will, she was a resident of California and then subsequently moved to Columbia.
And at the time that she executed the will, did she own this property in Tennessee?
She did not, to my knowledge. I do not think she did. I think it's a 1990 will.
In your brief, you argue that this California law should have been followed and she intended it to be followed. How do you argue that if in fact she didn't even own the property in Tennessee at the time that she executed her will in California?
I think that if we're gonna, and the will and the form nature of it and it being, 2 pages, this was discussed at the trial court. And did this decedent really understand the import of what she was doing? Did she intend to disinherit the daughter? Did she know about anti-lapse statutes? It's a sloppy will, it's a form will. But if we're gonna hold her to it, and disinherit her only child, then I think that we have to take all of the will as that's what she intended. And the will says she wants it to be administered under California law, and I think we have to give it as much weight as we give the rest of it.
Does it actually say administered under California law?
Yes.
Or does it talk about a statute in California?
It's
that
under,
sets out the rights of a personal representative?
pardon me, Your Honor, I have the will. Perhaps reading it would be helpful. Sorry, it's really small writing. It says, if the probate of this will is necessary, I direct that my personal representative petition the court for an order to administer my estate under the provisions of the Independent Administration of Estates Act.
And did you read that act and its provisions?
Yes, and the provisions are cited too in our brief as well. The Independent Administrations Act, it's a mechanism that is can be a little bit shorter in which to effectuate a probate case in California. It gives.
Doesn't it just essentially say that if you include that language in your will, then you as a personal representative have certain authority without court approval? But if you don't include it, you have to seek court approval to engage in certain activities.
Yes and no. There's two ways to do it under the administrative. You can be, I can't remember the legal word, but you can be like a fully appointed independent executor, and then you don't need the court approval. Or under the same thing, you can be a not fully appointed one, and then you do need court approval for things like sales. So both of those, it's not totally independent. It's one of those two, and both of them would come under that. Does that answer the question? Okay. So going back, apologies. All right. So under California law, the will directed Ms. Cox to ask the Tennessee court to do it. It's important because the real property goes into the estate. Then as stated in the estate of Weaver, decided by the California Appellate Court in 1958, the probate code 754 is what allows that when it is to the advantage, benefit, and best interest of the estate and those interested therein, the executor can sell same at public or private sale. Weaver further holds that upon hearing, the court must examine the necessity for the sale or the advantage, benefit, and interest of the estate in having a sale made, and must examine and return the witnesses in relation to the sale. Ms. Cox had the ability to contract to sell the property because it was advantage to the estate. As of July 2020, the estate had a mortgage liability of roughly $103,000. In her petition for probate, Ms. Cox valued the house at $209,000, which is $18,000 less than what this contract was for. Then, instead of acting in the best interest of the estate, Ms. Cox instead engaged in self-dealing. The will specifically disinherited her. She was nonetheless appointed the executor. She hasn't done anything to further the best interest of the estate for the heirs. In the over 4.5 years she's been executor, she's not located or served by publication any of the heirs. She moved into the property. She's still living there. She's paid the mortgage from the estate assets. Presumably she's paying her attorney out of the estate's assets, and she hasn't paid any rent to the estate. She's self-dealing. Her hands are unclean. She is exercising control over the estate's assets of the estates in her own self-interest when there is a route under California law for her to have finalized this.
And what route is that?
Under California law, the property is part of the estate, and she had the authority to execute the contract, sell it, put the money into the estate for these heirs, which would have been more than $100,000, and distribute it to the heirs. Instead, 4.5 years later, no money, no heirs, the heirs haven't even been found. Another $100,000 in cash has been depleted from the account. She hasn't done anything to transfer title to them. So
Let's back up just a minute though. Okay, you say she could have petitioned the court and the court could have ordered that the property be sold. What about, as I understand it, none of the title companies would assure title, is that correct?
Yes, and actually, I'm of counsel to limestone title. It's not, so when something like, when an airship issue comes in, they look at it and they go, okay, well, who, because ultimately, even with a court order, they're issuing title insurance. So if there's an error, there's no statute of limitations on them coming back at any point and making a title claim against the title company. So they're looking at it and they're looking at the will. They said, we don't think she's the heir. She can't sign anything as far as closing docs. The Tennessee real estate contract, and it was acknowledged in the order testified by an expert, the Tennessee real estate contract doesn't require you to be an owner of a property. You do have to get the property somehow before closing to deliver clear title, an assignment, or in this case, the title companies looked at it and said, we need disinterested parties to say who the heirs are of Mr. Harris, the deceased dead husband, or we need those heirs to sign this, because in our looking at this, that's who needs to sign. That is one path where this could have closed. Another path was...
How could that have closed then?
If, in that situation, okay, if we do it under Tennessee law, the only way my clients can prevail is either if the heirs had been willing to sign, the one brother was willing to sign, and they claim they cannot locate for the last 4.5 years the other two. There could have been a quiet title, and that was a trial.
What would a quiet title do?
Quiet title would notice them in their last, known area, and if they don't show up after the 30 days, the judgment's final, and a title company will issue title insurance on that. So the brother could have signed.
How would Tennessee have jurisdiction to issue or to prosecute a quiet title action against, were these people residents of Tennessee at any time?
They are unknown. We're being told we think they're in California. I think we could file a quiet title in California. The probate attorney for Ms. Cox testified at a trial that, yes, you could have filed a quiet title. That's the first time I'm thinking about that question. We've all gone under the assumption that you could, and the title company also agreed they would have accepted that.
But the quiet title action wouldn't result in Ms. Cox owning the property and then being able to sell pursuant to that contract that she signed when she had no ownership interest. It would just tell you that Mr. Harris's children are the owners of this property.
Respectfully, no, I don't think that's correct. So she signed the contract as the executor of the estate. In order to clear, and that contract doesn't say she's the owner. In order to clear title to sign the warranty deed for closing, right, she had to take additional steps. She may not have known about it when she signed the contract, but there were steps that could be taken that were not even attempted to be taken. She could have tried to get the other heirs either to sign or to file a quiet title, and at that point, we can close. She never needs to be the owner. She needs to, and that's part of the judge's ruling. There was testimony from a title company expert, and you can look at the contract in this case. It never says she's the owner. She has to deliver clear title at closing.
But wasn't there a mistaken belief that she was the owner, that she was the heir?
I think that I believe that she thought that she was the heir. I believe that, but that doesn't excuse her not just halting performance altogether. She just didn't even try to go forward. So under Tennessee law, there is, the only way she prevails under Tennessee law where the property passes outside the estate against the estate would be if the heirs, would sign, or if the estate is insolvent.
Let's assume you located them and they didn't sign the sales agreement. Then what? What are your remedies?
Then we'd be back to if you do it under California law, then she still would have had the authority to do it.
Did you cite any Tennessee authority for the position that she could administer this will under California law when the property is in Tennessee and the decedent was a resident of Tennessee at the time of her death?
I'm running very close to being out of time, but I did cite in my brief the standard in Tennessee for applying the laws of another jurisdiction. As held in Meiser Gresham Industries versus Cryotech of Kingsport, decided by the Tennessee Appellate Court in 2003, if the parties manifest an intent to instead apply the laws of another jurisdiction, then that intent will be honored. provided certain requirements are met. The choice of the law provision must be executed in good faith. The jurisdiction whose law is chosen must bear a material connection to the transaction. The basis of the choice of another's jurisdiction's law must be reasonable and not merely a sham or subterfuge. And finally, the party's choice of another jurisdiction's law must not be contrary to a fundamental policy of a state having a material or greater interest. She lived in California. Applying the fact pattern to these laws doesn't appear to be materially greater to an interest of the state of Tennessee.
The case that you just cited involves a contract dispute where there was a provision of the contract and the parties selected a state's law to apply to
Correct.
enforcement of the contract.
Correct.
Okay. How does that apply?
Because the only party here, I mean, you've got a deceased person, right? And you've got the personal representative before the probate court. Should be the only party asking to carry out the decedent's wishes to have her will probated under that provision. There is no other party unless an heir, I guess, objected to it.
Okay.
All right, thank you.
Thank you, Your Honors.
I believe you have 2 minutes.
Thank you, Your Honor. Well, first, this issue of applying California law is new, and it's a new issue, and that can't be raised on appeal.
What do you mean new? Was it not?
It was not raised at the trial court. It was not raised in any of the pleadings. There's nothing from the appellees saying, oh, we should be applying California law.
Are you saying that what we've just discussed for the past 10 minutes was never raised in the trial court?
I am, Your Honor. Second, even if it had been raised, this is the appellees who are not beneficiaries, they're not heirs, they're not interested parties under the will asking this court to construe the will. They simply don't have standing for it. And third, to get to Judge Armstrong's questions of how do you apply California law to a Tennessee probate based on regarding Tennessee real estate, the answer is you don't. Since 1867, Tennessee has followed the lex loci re citae doctrine, which means that the law of the property of real estate, the law where that property is located, is what's followed. That was in Weaver versus Sanders, which was 45-10-16, 1867, has been repeatedly restated by both the Tennessee Supreme Court and the Court of Appeals, most recently in regards to the estate of Miguel. And there, though, the Court of Appeals applied Louisiana probate law to a claim against the Tennessee probate estate, but that was regarding real estate located in Louisiana. So it was, that state's law was correctly applied against the real property located in that state, just as Tennessee's law should be applied to the property located in this state. Now, with the seller, the contract saying the seller is not required to be the owner, that was testified to at trial. And that is a very literal reading of that contract, but Tennessee law is clear. You can't convey what you do not own. Leibowitz versus Porter, very similar situation. A man contracted to sell property he didn't own, didn't have any power to make himself the owner, and the court found that contract was a nullity.
Okay. Use your time.
Thank you.
Thank you, counsel. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. We will stand in recess to the call of the docket this afternoon.